know I was having some issues in the beginning trying to, get myself acquainted with Canvas. So thank you guys all very, very much. I so enjoyed teaching. I hope you guys stay in touch. I put in the chat my cell phone. So if you guys ever want to just grab coffee or have any questions about anything we discuss in the class, or if you just have questions about family law or working as a paralegal, please, please, please feel free to reach out to me. I'm here to help you in any way. And I'm just so happy that you guys were my students this semester. And again, thank you so much for being patient with me and having me work through the kinks. I appreciate all of you very much, and I hope you guys stay in contact throughout the years. I'm here as a resource for you guys in any way, shape, form that I can be. So again, tonight's the last class. I enjoyed all of you very, very much. And again, please feel free to reach out to me anytime, even after this class. I put my two cell phones in the chat, so you guys are welcome to contact me anytime. So let's do roll really quickly, and then we're going to start on our last module. I'm almost going to start crying. This is just so amazing. It went by so quickly. But again, thank you, everyone. Is Jacqueline here? Jacqueline? Actually, I see Jacqueline. I'm marking you as present.
Here.
I see
Yes.
you. Okay, perfect. Yolanda? Yolanda? Melissa?
Present, Professor.
Thank you. Ciao. I see you. Thank you. Ariana?
I'm here.
Perfect. Jocelyn?
Here.
Thank you, Jocelyn. Myra? Myra. Okay. Let's see you. Sergio? Sergio?
Yes, I'm here.
Thank you. Delandria?
Here.
Thank you, Delandria. Jesse?
Here.
Thank you. Carolyn? Thanks, Carolyn. Sandra?
Here.
Thank you, Sandra. Gary? Gary? Lisa? Lisa? Bridiana, I see you there. Brenda? Brenda? Tara?
Present.
Tara? Okay, perfect. Carla? Paula?
Here.
Thank you, Paula. Isaac?
Here.
Thank you, Isaac. Mariah, I see you. Jessica? Jessica. Jacqueline? I know you were there. I know you were having some issues. So Jacqueline, I'm marking you. Elena?
Here.
Thank you, Elena. Brittany? And Leslie. All right, you guys, we're on our final module, and it's going to be an overview of the litigation process. Some of this is not going to be relevant unless you guys decide to make the extra step and go to law school and become attorneys, which I all strongly suggest that you guys do. I think you guys all have the capability, and if you're interested and want to spend a lot more time reading books and things of this nature, I certainly think all of you guys would succeed if that's, the next step that you want to take in your educational process. If you don't, that is great as well, because the attorneys certainly need all the help that we can get from our paraprofessionals. So the litigation process starts with the petition in family law. As the slide says, in civil matters, it's a complaint, and then in criminal matters, it's an indictment. But here in family law, we start out with the petition. I know we kind of went over this in some of the prior modules, and I wanted to show you. I have all the forms up. All these forms are also in the module, so you should be able to see them there. But I wanted to kind of do this contemporaneously. You guys can see my screen, right? Yes? Okay, I'm going to assume that's a yes. All right. So in California, and most family law practitioners will have some sort of forms program, IUCB, which I think is California Educational something or another. LexisNexis has it, Westlaw has it. You can also just get these from Googling judicial council forms. They're available. These forms that the attorneys get are just easier for us because we can pre-populate certain one of these forms. Like this will always have my information and my firm information. But this is the start of all divorce proceedings or legal separation, nullity of either marriage or domestic partnership. So this is the form that starts everything. And it's a 3-page document. They change these forms pretty frequently. If you look at the bottom left-hand corner of any form, I don't know if this is large enough for you guys to see, but hopefully you can see my cursor. You can see that this form was last revised in 2020. It is important when you file these forms, if for whatever reason, if you work for a firm that uses just a judicial council forms online, or maybe you use old forms, just double check and make sure you're using the most recent form. You can just Google, am I using the most recent form? This used to be a 2-page document. They've now made it into a 3-page document as of 2020. Well, maybe even before 2020 was 3 pages, but at least when I started back, whenever that was, this used to be a 2-page document. It is now 3 pages. It's pretty self-explanatory, and it's not, it's just the basic information. So whether you're married or domestic partners, the statutory requirements that we spoke about in the earlier modules regarding the your right to file in California. So whether you're a resident of the state, resident of the county, you have the information regarding, the length, the statistical information. If you have children, you put it in there. The grounds, and the slides will go through this a little more, but the grounds, so whether it's divorce, nullity, or nullity based on voidable marriage. If you have children and child support, you'll put the information here. If you're asking for spousal support, you put it in there. Community property. I can tell you in my practice, and I'm going to speculate, for about 90% of family law practitioners in California, we have boilerplate language for this. So even though it says, list all the properties, when you file a petition, you really don't know everything. Sometimes the disclosures aren't completed yet. So we usually use boilerplate language for 10 and actually 9, which is a separate property. And the boilerplate language is just basically, we'll amend this once we find out what it is. We don't know the full extent and nature of our property, our assets, our debt, so we'll just amend it at a later time. So as you can see, it's just very, very basic information. It doesn't go into details of everything that you want. And I know in my practice, when I fill this out, I always ask for what I consider the most that my client could possibly get, because it's better to ask for more and then settle for something less than to ask for less and then have to amend it or do some other things. But this is a petition. You'll start every single divorce action with this form, along with the summons. So the summons for family law, again, 2-page form. You're going to just fill out, the first page of this. So if it's really simple, there's no children, literally it's a summons and petition. I have found that most counties, including Orange County, we have some local forms that will have to be filled out as well. But for those jurisdictions or counties that don't have local forms, it's going to be the summons and the petition. And I can tell you in my practice, the initiating forms always prepared by my paralegal and my assistants. So I know they are really familiar with this form. And again, once you do, 2, 3, 4, it's pretty routine. My firm has a questionnaire that essentially has the clients respond to the information that we need to fill out these initial forms. So this is the petition. And then once a petition is served and filed on the husband or the wife, that person then needs to file what's called a response. So in response, in family law, the document is known as a response. So here is the response. It pretty much mirrors the petition. And as you can see, you're just if you're responding and you have a client who comes in and says, hey, I was served with a petition for dissolution. What do I do? Well, within the statutory period of time, which is 30 days from the date, if you were personally served with the petition, you have to file what's called a response. So again, this is pretty much the same actually as the petition. So the response gets to basically say, well, I'm responding and this is what I want. Again, fairly basic information. It doesn't go into details of saying, hey, I want the TV, I want the washing machine, I want the car. I mean, you can put that in there if you want, but it is just very basic regarding, basically the start of the action and what the person who is responding wants. So again, very, very basically, this is what you're going to be filling out. The other form that needs to be prepared is what's called the UCCJEA. I believe I brought this form up in prior modules, but if the parties have children from the marriage, this UCCJEA has to be filled out and filed along with your petition or the response. And even though a petitioner has filed it, when you respond, the respondent also has to file this UCCJEA. Again, I use my paralegals and assistants exclusively to fill out these forms, the initiating documents or the response. Frankly, because it doesn't make sense to charge clients to have an attorney do this, because again, this is usually the beginning phases and it's just very rudimentary with the information that you're filling in there. So that's the UCCJEA, and that will be filed and served along with the petition and the response if the parties have children. Okay. Okay, and it says once a petition and response are filed, the matter is ready to be scheduled for trial. I don't 100% agree with this. As it says, you have to do discovery, you have to do your PDDs, depending on how complicated the matter is. The discovery process, which essentially means I can ask the other party written questions. I can set what's called a deposition, meaning I have them come into the office. I have a reporter there who types in everything I ask, what the other person says. I can ask what's called request for production of documents, saying, hey, give me all these documents which are relevant for me to figure out what the assets and debts are of the community. There's also what's called a request for admissions, meaning, hey, admit this is true. And if it's not true, why isn't it true? Family law also has family law form interrogatories. Those are literally just judicial counsel forms that you just kind of check off. In fact, let me show you guys that. The other discovery that I just discussed, like the document production request for evidence, a request for admission, special interrogatories, those are specially prepared. It isn't just a form, but the form interrogatories, which I will show you. So as you can see, this is a pre-printed judicial counsel form. So anything like this is identified as a judicial counsel form because the judicial counsel has made these and they try to make things easier so that if there's something that people use all the time over and over and over again, they'll just make these forms. So as you can see, you can just check off whatever questions that you want answered. This is pretty pro forma in most of my cases, unless it's a very, very simple case with very little assets, no children, all of that other stuff. But in any case that has any sort of assets, or if I think it's going to be contentious at all, this is pretty much something that goes out in all of my cases. Okay, so again, I think to say that's ready to be scheduled for trial is not necessarily true. There's a lot of things that come pre-litigation, again, outside of it being a very, very simple case, discovery, at least some sort of minimum discovery, or, you know, the exchange of PDDs, which again are the income and expense declaration. This is a 4-page document which goes over literally your income and expenses. And this document is very important in order for the court to determine if and the amount of both child support and spousal support. It's a 4-page document. It's pretty self-explanatory, but this form too, routinely in my practice, income and expense declaration, I have my assistants communicate with my clients to get the information and to prepare this form. And then the other form that is part of what's called the PDDs, again, preliminary declarations of disclosure, is the schedule of assets and debts. It is what it purports to be. It's a schedule of all of the assets and debts that are known to you. It's a 4-page document. It's pretty self-explanatory. You know, they ask what real estate you have, what furnishings, jewelry, vehicles, bank accounts, stocks, debts, and, you know, other debts that you may have. And again, those 2 forms, the schedule of assets and debts and income and expense declaration, these have to be exchanged in dissolution matters and legal separation matters before the court will ever have a trial. There has to be literally a form, a declaration regarding the disclosure of the income and expense declaration and the schedule of assets and debts before a court will set a trial. Most judges are on top of it and they'll review the file before a trial is set. And they'll say, okay, you know, have the disclosures been exchanged? And if not, they're not even going to set a trial. In Orange County, and again, every county is different, but if one side wants to get a matter set for trial, we have a local form, and it's called At Issue Memorandum for Trial Setting. And we fill this out and we serve it and file it with the court. And once the court gets this in Orange County, and every county is different. In Orange County, what will happen is then the court will set a hearing to determine, okay, is this really ready for trial? And if it is, they'll set a trial setting conference and they will make you go through a mandatory settlement conference. And that usually involves either literally the attorneys going into the cafeteria at the court and meeting with their clients to try to resolve matters, or they will have a settlement officer available for the parties and attorneys. And settlement officers can either be retired judges. We had a program here in Orange County that was great, and we used to have retired judges who would help the parties. And we also have other fellow practicing attorneys who volunteer their time to try to help the parties and attorneys settle matters. So in Orange County, it's kind of a hodgepodge. It kind of depends. Sometimes there'll be great programs available. Sometimes it won't. I think we had Human Resources of Orange County offer services at some time. But worst case scenario, at least in my opinion, worst case scenario, what the judges will make you do is have the attorneys, if they're attorneys, or the parties, if there are no attorneys, meet and confer literally the day of the MSC. You go outside, you talk, see if you can settle it. If you can't, then you come back and you tell the judge. And at that time, you tell the judge, okay, this is my time estimate. We think it's going to be 4 days. Here in Orange County, most trials are set in the afternoon. So if you think it's a 4-day trial, you'll literally get 8 afternoon trial settings. And the longer your time estimate, the more likely it will be set out really, really far ahead in the future. Or if we're lucky, sometimes there will be judges who will hear what's called long cause matters and they can, send you out. But I've noticed in Orange County now they try to keep the same judge who is basically your assigned judge all the way through trial. I have a matter, let's see, I had a trial setting conference last month for 2 half days, and we got an April trial date. So these things are really set out far, and it's kind of hard to, when clients ask, because obviously that's the most important. It really does depend on each judge. Believe it or not, even though it's all in Orange County, each judge has different caseloads. Orange County, we're constantly turning over judges. So when, cases are being reassigned or you get a new judge, then that even causes more delay. So it is, everyone thinks, oh, 6 months and one day I'm going to get a divorce. It's usually not like that, especially if it's contested. There's going to be probably a lot of drag time. And even after you file this, I mean, it could literally be a year after you file this saying everything's ready, just based on having the MSC set and then coming back and telling the judge, well, these are the issues and this is how many days that I need in order to go to trial. So this is a local form. I believe LA has a local form as well. I'm not sure. San Diego also has a local form. I'm not sure about Riverside or San Bernardino, but I know for sure in Orange County we have this local form. And if you think your matter is ready to be set for trial, this has to be filed afterwards. Okay. I'm not going to go over actual trial again. If you guys end up being attorneys or if you have questions, read through this or you can ask me, but this really is more for attorneys. And again, each county and each judge is different. I don't necessarily agree that a judicial officer will conduct a mandatory settlement conference on the day for trial. If you are trial set, and some of the judges here in Orange County, if there has been a trial date set, you better be ready to go that day. Very rarely will they continue it outside truly of some sort of emergency, but you should be ready to go that day. They're not going to send you out for a mandatory settlement conference unless, again, there's some special reason or the judge offers it. But, when you've set a matter for a special set trial, meaning, hey, I've specifically asked for this date, and the court has carved out that time for your case only. Time is very precious, especially here in Orange County. You should be ready to go forward. There's going to be no more negotiating. Obviously, if you do, the judges are going to be super happy. They're going to thank you. They're going to say, great, we're so happy you settled. But, if there's any sort of dispute, you need to be ready to go forward. I've rarely had a trial judge refer parties to a mediation. And again, a judge can't force parties into mediation unless they're specifically talking about a mediation for child custody, that they can do, but not just a general mediation where people try to resolve all issues in the case.
Is there a reason why there's like a judge turnover rate in Orange County as opposed to like Riverside County or?
Oh, okay, then let me be clear.
Oh.
All counties has
Oh.
been my experience. And I think that's because, frankly, family law is very high emotion. I think there is a fair amount of pro se litigants in family law as well as compared to, obviously in criminal, you're always going to have a public defender or something. Also, it's always going to be two attorneys. And then in civil cases, I also find that most people have attorneys. So I think there's just a lot of burnout. I always think I could never be a judge and sit there all day and listen to, everything that everyone is saying. People are just always upset and raised voices, all of that stuff. So, we have a few family law judges now here in Orange County who used to practice. I mean, like we used to practice with them. But for the most part, my experience has been that most of the judges, regardless of what division you go into, either come from the district attorney's office or public defenders. Like it's still within that group. I think there's more of private practice people who come in. but I just don't think they're used to it either. They're used to doing the criminal or the civil. It is a little bit more civil, and then family law, because it is such a mishmash and it's just such high emotions. I think most judges want to do their time. And I'm not quite sure if judges have to do everything, like they have to go through probate, family law, criminal, civil. I don't know how the inner machinations work. I think they do. So, most of the judges will stay the minimum amount of time, maybe a year or 2 years, and then they'll try to go on to something that they're more familiar with, whether it was criminal because they came from the DA or PD's office, or if they were in civil practice and they'll want to go to the civil division. Again, so that's been my experience. We certainly have had judicial officers who stay a long time in family law, which is nice because then you can have a judge listen to your client's case and understand the full nature and extent of it. But yeah, that's been my experience in any county. I mean, there's just a high turnover of family law judges in every county, at least counties that I practice in. Okay. Again, I'm not going to go over the litigation practice because, again, unless you guys, which I hope you guys do, but unless you end up practicing family law, I don't know that this is necessarily important. And again, I don't think this is necessarily one size fits all. Every judicial officer, even if it's within the same county, has different ways that they want you to present the cases. Sometimes they will put out just kind of like an outline as to what they want you to do, or at the TSC, or when the trial is finally set, they will tell you, okay, this is what I want from you. This is when I want your witness list. This is when I want your exhibit list. But I think it's very hard to say, okay, generally this is what's going to happen, because even in the same county, each judicial officer is different. And here in Orange County, up until about a year or two ago, we had the judges started doing what's called standing orders, and it used to be, no joke, like 10 pages of all these things that you had to get done before the trials. And then there was an uproar within the family law bar, and we're like, hey, we don't want to do this. This is too onerous. Nobody can get to trial with all these rules. And so maybe about a year or two ago, they stopped it. So now there's nothing. We're supposed to do everything by code and also local rules. But again, even with the judges getting rid of those standing orders, they still have their own proclivities. And what I do is I will either call the department directly if it's a new judge, or have my assistant call and say, okay, what exactly does a judge want for what I consider long cause hearings or a trial? So again, unless you guys end up becoming attorneys, I don't necessarily think this is important, but I certainly encourage all of you guys to go to law school and become attorneys. Hang on for 1 second. My dog just came in and I gotta get rid of her. Hang on. About that, guys. Okay, so I'm gonna get rid. I'm not gonna go into this. Okay, client interview. So the initial client interview, I use my paralegals and assistants extensively. Either they will at least, if they answer the calls, just kind of get an idea of what is happening, so that when I meet with the clients or prospective clients, I have general understanding as to what the issues are. Also, I will routinely have my assistants or paralegals sit in with me when I do the initial consultations, just so that they can take notes and kind of help me, because again, they'll be doing most of the initial forms. So I find it really important to have my paralegals in the office with me. And yes, it does. So depending on the level of experience of the paralegal, I'm super blessed. My paralegal has been with me for over 20 years, so I trust her implicitly. Again, if you guys end up becoming paralegals or paraprofessionals and decide not to go into law school, frankly, outside of going into court, I am confident that my paralegal and a lot of the paralegals that, you know, I deal with from other offices could very well do everything that I'm doing. The only difference is that you guys don't go to court, which may actually be a good thing, but everything else, I trust my paralegal to do everything. Client information sheet. I do use a client information sheet. It just kind of depends. You know, if it's somebody that's a referral to me and I know they're just going to retain me and I just need to do, or a friend, you know, I will just send out a questionnaire that I've kind of modified throughout my years of practice. I know the service I use, which is Westlaw, they also have like a pre-printed form, but those are pretty easy to find. And if you join in on a established family law firm, I'm sure every single firm has their own different forms that they use or intake forms or whatever. But it is important to get the basic information at a minimum, at least so that you can get the petition started and filed with the court. Yes, this is just so, as the slide said, the information sheet is important, or at least take some notes. I mean, I've been doing this for so long now, I kind of know what needs to be done. If the client ends up retaining me on the first visit, which I don't usually recommend, I'll tell most of the people who come in to see me, and especially if I'm the first attorney, hey, you need to interview as many attorneys as possible because this is a very important part of it. It's going to be very, very important in your life. And you need to make sure that the attorney that you retain, you feel comfortable, that you have a good relationship with them, because there's nothing worse. You're already in a very acrimonious situation. If it's a high conflict case, you also don't want to be, you know, in some sort of fights or disagreements with your own attorney. So, you know, I always tell people who come in, if they talk to me first on the phone or they, you know, I'm the first attorney they see, I always recommend, please talk to at least 2 or 3 other attorneys and then pick the right attorney. Because the other thing that happens a lot in family law is that people will go through 1, 2, 3, 4 different attorneys. And I get it. You know, sometimes the personalities don't work and you don't find out until later. But I can tell you, you know, just generally judges and, you know, other attorneys, once you start getting on to your third, fourth attorney, and obviously there are exceptions to the rule, you know, the judges certainly will start to think, okay, maybe the client is the common denominator. It's not every single attorney was bad. You know, maybe something's going on with the client. So not to say that if you only have one attorney, that makes you the best person. That's not what I'm saying, but it is really important, I think, to make sure that the client not only feels comfortable with the attorney, but frankly, that the client feels comfortable with all the support staff, because for the most part, their first point of contact is going to be, you know, the receptionist, the assistants, the paralegals. And I know there are a lot of firms here in Orange County where 90% of the communications is between the paralegal and the client. My office is not like that, just because I think it's important for clients to talk to the attorneys and make sure there's a relationship. And I'm not saying it's good or bad, but there are a lot of firms here in Orange County and all over, you know, California, where the paralegal is the main point of contact. So it's important that the clients feel comfortable with the paralegal as well, because obviously you guys are the ones that are going to be, you know, interacting with most of the clients, and that they feel that they have a good rapport with you as well. So choice of actions. So when we fill out the petition for dissolution, you get to pick dissolution of divorce of marriage or domestic partnership, legal separation of marriage or domestic partnership, or nullity. So one of these things will have to be checked, and one or the other of these have to be checked. So we spoke on prior modules. The difference between dissolution and legal separation is that with dissolution, that bifurcates the marriage, and then you can get remarried, do what you want. With legal separation, you're still legally married. And I find that most of my clients will want a legal separation versus a dissolution or a divorce. either because of religious reasons or sometimes for health insurance issues. So for example, usually if you are covered under your spouse's health insurance, if you divorce, then that person, in most instances, if not all instances, cannot stay on the spouse's health insurance. So if one spouse has significant health issues and for whatever reason can't, get their own health insurance and the other spouses, sympathetic to that, instead of getting a divorce, they'll just get the legal separation so that the spouse can continue on their health insurance. That's really the only other time, other than religious reasons, why people will use legal separation, or they will say, okay, we'll do a legal separation up until this time, and then we'll file for dissolution. But again, so religious or health insurance or something else, where if you get a divorce, you can't enjoy the benefits of being a married person. Nullity, there are different reasons for nullity. So that's on page 2, number 5. And so nullity can be void, meaning, hey, it just, the law does not accept this because of either incest or bigamy. So if you're asking for nullity because of incest or bigamy, that means the whole marriage is just going to say, okay, it shouldn't have happened. It's against the law. Nullity avoidable marriage means it can be voided by the court. So petitioner's age at the time of registration. So let's use an extreme example. They're 5 years old. Obviously, you cannot get married. A prior existence of marriage or domestic partnership. Let's say somebody said they didn't know that they were still married. I had a case like that where my client thought that he had gotten a divorce. It never went through, so he got remarried, unbeknownst to them. And an unsound mind basically means one person or the other did not have the ability to enter into basically a marriage contract. Fraud commonly happens. I've seen fraud for, let's say, like immigration purposes. If one person is alleging, hey, the only reason they married me was because they were trying to get some sort of immigration benefits. I didn't know that at the time. So I want this marriage to be voided. Force, literally, I mean, the example they always give is somebody put a gun to my head and said, if you, marry me, then you have to, otherwise I'm going to hurt you. And then physical incapacity. So I will tell you, less than probably 5% of my cases ever deal with nullity. I think that's a very, very small exception. Most of the cases are going to be divorce or legal separation on these grounds. And I know the slides get into great detail about nullity, but I'm going to kind of skip over that because, again, I don't see it happen a lot in my practice. And I just don't think it comes up a lot. Maybe I'm wrong, and for whatever reason, my practice, I just don't get a lot of nullity cases, but I just don't see it a lot. Not that I haven't had it, but it's been very few and far in between. I think most people are going to be coming to you because they just want a divorce, and it's not because of the nullity for void or voidable marriages. So I'm going to skip over a lot of these slides, but of course you're welcome to peruse. If nullity really interests you, go through the slides and the reading material. They go quite in depth over the grounds for the nullity. So.
Is nullity on the bar?
I'm sorry, can you repeat your question?
Is nullity on the bar?
On the bar?
Exam.
On the bar? The bar exam, I'm trying to remember. I think family law and community property, it's one of the areas that can be, oh my gosh, it's been so long since I've taken the bar. So I know there are core concepts that will be in so there's like a multiple choice section, there's an essay, and then I think they call it a performance exam. And it may have actually changed since I took the bar, which was literally many, many years ago. But I think with community property, it can be one of the essay questions because it's California specific. I don't think they always specifically ask about nullity on the bar. It's just whatever they ask at that time. And I can, gosh, I'm trying to remember. I don't think they have to. I don't think it's one of the required topics or areas of the law that are in, like that are always in the essay questions or that is always in the MBE. I hope that answers your question.
It did, thank you.
Oh, of course. I don't know why they go on so much about nullity. Okay. So let's get on to dissolution and legal separation. The most common method of terminating marital union is through the procedure of dissolution. Again, this is the petition for dissolution form. California also offers an action that results in legal separation. So the legal separation will not terminate the marriage. So again, you guys are, the people will still be legally married. You cannot marry somebody else. Everything else can be done. You guys, they can have a custody judgment. They can have a judgment regarding the division of assets and debts, but you cannot remarry. So procedurally, these actions are virtually identical, true, and with the exception of the distinction of continuing the marital union, the results available in legal separation are exactly the same, 100%. I don't know if this is going to go over it, but one other thing, and I know we discussed this before, if for whatever reason at the time you file, you do not meet the jurisdictional limit, meaning you weren't a resident of California for 6 months or a resident of the county where you file within 3 months, you can file a legal separation. And then once the statutory time, and then let's say, you decide to move to Santa Barbara County for whatever reason, but you want to file in Santa Barbara. You can still file in Santa Barbara as legal separation. And then once you've been a resident of Santa Barbara County for 3 months, then you can amend it and then amend the petition for dissolution. So it's a 2-step process if you don't meet the jurisdictional requirements. And I do that a lot for whatever reason. If somebody moves from one county to another, I just had a gal who lived in Kern County. She moved to Orange County. She had not been living in Orange County for more than 3 months. So I let her know, hey, we'll do legal separation first. And then once you're a resident of Orange County for 3 months, then we'll move that to divorce. Here's one other thing, and it may be discussed in the slide. If somebody wants a divorce and somebody wants a legal separation, the divorce is going to trump. You can't argue about, oh, well, I want a legal separation, so I only want the legal separation. If one person wants a divorce, then it's going to be a divorce. So let's say, for example, you file as a legal separation and there's no jurisdictional issues, and then the other person files as a response for dissolution, then it's going to be a dissolution. It's not going to be a legal separation. The dissolution is always going to take precedence over the legal separation request or response. So the grounds for obtaining a dissolution and legal separation found in Family Code 2310, irreconcilable differences. So this is for divorce or legal separation. So back in the day, California was not a no-fault state, meaning you had to show a reason. They got rid of that. I don't remember when, but they got rid of that a long time ago, certainly before I started practicing. So all you have to say is there's irreconcilable differences, meaning, hey, we just don't get along. We don't have to give a reason. As long as you check this box, then you're good to go. You don't have to give a reason and say, oh, somebody cheated on me or they stole my money. It doesn't matter, and the courts don't care. As long as you check this box off, then you will be fine. Permanent legal incapacity, while available, is rarely used as a grounds for a dissolution action. Yes, I don't think I've ever checked that box. I don't think I've ever checked this box. It's always been irreconcilable differences. To prove permanent legal incapacity requires introduction of medical expert opinion testimony attesting to the party's incapacity at the time the petition is filed. So that is actually new to me. I did not know this. So that's very interesting because I've never checked this box. So, but now you know. So if there's some reason and if you have to get a medical expert, then that is a grounds, and you would have to go through the extra step or having some sort of medical expert testify that they were incapacitated at the time the petition was filed. Family Code 2311 gives a definition of irreconcilable differences. Are those grounds which are determined by the court to be substantial reasons for not continuing the marriage. So again, I don't even think this is necessary. Once that's checked, and if you go into court and you say, I want a divorce, that's all they're going to ask. One of the questions that judges ask or the attorneys will ask of their own client is, has there been an irreconcilable difference in your marriage? And parties say yes, and that's all you have to do. They're not going to really go into anything more than that. Okay, summary dissolution. I usually don't, our office doesn't usually handle summary dissolution because in a summary dissolution, it's usually when there aren't a lot of assets, there aren't a lot of, there's no litigation. The process is quick and inexpensive and without participation of attorneys, 100%. I'm certainly aware of this, and I believe if you Google summary dissolution or even Orange County summary dissolution, it will provide you with a list of the forms that you need in order to get the summary dissolution. It's a much more truncated process, very easy. I know if I have potential clients call and say, hey, listen, we've only been married for, a month, we have nothing, we have no children, I will often refer them out to Family Court Services or the Self-Help Center at our courts. Here in Orange, I believe the only self-help center for family law is at the court on the City Drive. I don't think the Santa Ana court has a self-help for family law, even though we have a smattering of judges there. But summary dissolution, again, just depending on certain factors, and those factors are they're on page 335. That will be in your reading material. But this is good to know. And if you guys, want to do just summary dissolution for parties, that's certainly an inexpensive way to help parties out that don't need the services of a full-fledged attorney. I always say, unless you guys are really there's some thorny issues, if you can work things out, either go to self-help or go to a mediator, because it's going to be a lot less expensive and you can get everything taken care of, in just a more amicable manner. I mean, most people hire attorneys because there's something that they can't agree upon, or there's domestic violence or something like that. So summary dissolution is a great process. Again, I think you can just Google summary dissolution and it'll show you the list of forms that you need to fill out. In my practice, I don't do this a lot. And I don't think as paralegals, you'll be working for firms who help out a lot of clients with summary dissolutions. I'm sure, if you start working in family law, you'll get calls from friends and maybe family and asking you about this. And again, just Google it. I'm 99% sure every county will have some sort of PDF that will say these are the forms that you need to fill out in order to finalize pursuant to summary dissolution. Okay, summons, we already went over this, so we need this form. They will not process anything if you do not have the summons. There's also summons in civil law. It's just a fancy word saying you have been summoned, you're being sued. In this case, you're being, served with a petition for dissolution. So 30 days after the service of the summons, the petition, UCCJEA, if you have children, other local forms, if that county has local forms, you have to file a response. If you do not get a response and there's no agreement to kind of hold off on the response because you're either trying to work on a settlement or whatever is happening, then the petitioner, the person who filed this, can file what's called a request for default. So Here's that form. So, you wait 31 days, person hasn't filed a response, you have no idea what they want or don't want. You or, the attorney's office can file a request for default. Basically what this means is, hey, court, 30 days has lapsed. Respondent has not filed their response. I just want to proceed. I don't want to wait. Let's get the show on the road. So you do the request to enter default. You can, it's pretty self-explanatory. I have my paralegals do this all the time. There are certain things that have to be checked. As to, the petition does not request money, or this is a parentage action, or there's no issues of child support. You have to mail the request for default to the respondent. There are also some declarations you need to sign regarding military status. Obviously, if the respondent is in the military, there are certain exceptions to be able to file the default, and they have the military status here that shows whether or not the person is in the armed services. But if the person does not respond within 30 days, day 31, you can file this. I will say, if the person files what's called a request to set aside the default within 6 months, most courts will, and in some instances has to set aside your request for default, because the courts ultimately want the substantive issues litigated if possible. They're not going to want to deprive somebody of not having their day in court. The person may say, hey, I know it says I got served, but I never got served. The only reason I knew about this was because I got this request for entry of default. Or I have had other parties come in and tell me, like, oh my gosh, the other person told me I didn't have to file anything. They were going to take care of everything. And the next thing you know, they have this default judgment against them, which says everything goes to the other person. So there are some certain code sections which state, if you file something within 6 months, before the judgment or entry of default is entered, they will set it aside, and then you get to litigate the case. And I also have clients who come in, and as paraprofessionals, I'm sure you'll run into this as well if you go into family law. They'll call and say, oh gosh, I was served with this. I'm just not going to do anything. I'm not going to do anything. Please don't. I mean, it's so important that people understand that there are huge ramifications of not doing anything. I'll have people call me all the time saying, oh, but there's nothing here. What am I fighting about? I didn't sign anything, so I'm not going to do anything. I'm going to sit on my hands. Well, you don't know what the other person has said. You don't know what the other person is going to tell the judge. You have no idea what the other person is going to request from the court. And if your default is entered and you do not file a separate motion to set that aside, even if you go to court, the court is prohibited from even hearing you because you've been defaulted. So even if people think, oh, what's a big deal? I don't care. Let them take a default judgment. I always tell people who call me, just file something. If it has to do with cost, you can get a fee waiver. They'll file it for you for free. But it's really dangerous to let it go past the 30 days. At least, they can call the other attorney or the other party to seek some sort of extension. But it's super, super important. That 30 days is really, really important. That you have that calendared. If somebody calls the office, if you're a paraprofessional or an attorney, that you find out exactly when they were served, so you can get that 30 days calendared. And if they retain, the firm, that you make sure that the response is filed and served within that 30-day period, because the consequences are huge, obviously. Okay, so proper service is extremely important. I think this is kind of touching on what we discussed in prior modules. The person has to either be personally served, or they have to be subserved, meaning somebody can go out and try to serve them a couple of times. If they can't serve them, they can be subserved, or service by posting or publication. But if somebody is personally served, then they have notice of, what the petitioner is requesting. And again, service is very important. Improper service can result in a void judgment. We discussed that before as well. So, gosh forbid somebody files a proof of service saying somebody was personally served, but you can prove to the court like, hey, I wasn't even in the country. I've literally had cases like that where somebody files a garbage proof of service saying, my client was personally served, and we can prove through passports or other things I wasn't even in the country. That's going to make it void. That's also going to make the other side look really bad because obviously they have either filed something, they've hired somebody who is filing a perjurious proof of service, or if they filed it themselves, it just puts a bad pallor on whoever has filed a proof of service that is not true, and proofs of service are signed under penalty of perjury. So not that I certainly haven't seen it happen in my practice, but that is a felony. If you sign something under penalty of perjury and you find out that it's false, potentially there are criminal ramifications for that. I've never seen that happen, but it's certainly a possibility. Once a petitioner serves the petition and summons, the person who actually serves must file a separate document known as proof of service. Attorney maintains proof of service until it's filed with the court. So yes, I always use process servers. Sometimes my clients will say, well, I can have somebody do it for me. That's fine and dandy, but it is very important that whoever ends up filing or serving the summons and petition or other documents that need to be served, that they sign the proof of service. And then that proof of service needs to be filed with the court, because that's what shows the court, okay, this person was properly served with the documents. Depending on the company that you use to act as your process server, sometimes they will do it for you. It just depends. I've been with my process server I've used, I've been with him for over 20 years, and he kind of takes care of everything for me, and he'll go ahead and get things filed for me as well. So that's nice. But every company, every process server is different, but it is very important that after the respondent is served, you file that proof of service with the court. Otherwise, you're never going to get a judgment. I mean, they're going to make sure that the other person was served. So this is actually important. Okay, let me go back to the summons. Okay, so on the back of the summons is very, very important boilerplate language. It's very important. So if as paraprofessionals or as attorneys, you meet with your clients, when you initially file or when you get these summons, it's very important you go over these standard family law restraining orders. They're commonly referred to as ATROs, or automatic temporary restraining orders. Let's take a little bit of break. I need to get some water, and then we'll pick up from here. I'll be back in about 10 minutes, and then we can go over the back of the summons, because this is really important. Okay, see you guys in 10. On my break. Thank you. Yes, it was recorded, and then 5 minutes after break, I'm starting it again.
Thank you.
Thank you. Okay. So the final provision is you must notify each other of any proposed extraordinary expenditures at least 5 business days prior to incurring these extraordinary expenditures, and account to the court for all extraordinary expenditures made after these restraining orders are in effect. So if you want to buy a new expensive car, you have to notify the party at least 5 business days for doing so. However, you may use community property, quasi-community property, or your own separate property to pay an attorney to help you to pay for court costs. So you are allowed to use community, separate community, quasi-community property to pay for attorneys. My sense is that, most of these judicial council forms are, judges, we're all attorneys, legislators. So we always make a carve out provision for attorneys, and you can pay your attorneys. You can liquidate stocks if that's the only way you have to pay for attorneys, and you won't get dinged for that. Okay. Orders are self-explanatory, print on the back side, designed to maintain the status quo. Yes, but again, I find that too many people, including my own clients, other parties, will violate these routinely. So I cannot begin to tell you how important it is if you are the point of contact for the firm, or you become an attorney, or the attorney asks you to go over, important things with the clients. This really is important. They need to know about this, because far too often there will be litigation regarding this, meaning somebody, one or the other party, will file an RFO saying, hey, somebody's violated the ATROs. It comes up all the time. So if you just know about it beforehand, then you won't have to worry about somebody accusing your client or having to go into court to file a violation of ATROs. So again, pretty self-explanatory, but it's very important, if you are the point person and you're the one going over these forms with the client initially, that you really, really review this part of it. It's very important, and it's a source of a lot of litigation and a lot of headache. Okay, I think we went over this already. The initial filing, again, the summons, the petition, UCC, JEA. Most of the forms available for use in family law proceedings are mandatory and must be used. That is correct. So unlike civil, where you can do a lot of stuff on pleading paper, for family law, you have to use this pre-printed summons. You have to use the pre-printed petition. You have to use a pre-printed UCC JEA and the pre-printed response. Now, there are some other forms where you can use either the judicial council forms or you can use a pleading, but there are some initiating documents, like the ones that we're just going over, that are mandatory. You can't, draft the same language on some sort of other form or a pleading paper or something else that's equivalent. There are some other forms that you can, but for the initiating documents, these are mandatory. Okay, so we already went over this. It's the petition and response. Again, it's pretty self-explanatory. It's the bare bones minimum of what each party is requesting from the divorce action. We went over the FL 100, FL 120. Again, all of these forms are going to be in the litigation form module on module 8. So additional options available to respondent. They do not have to file a response. Once served, the respondent must decide whether to submit to the court's jurisdiction or challenge the court's exercise of power over him. So that is true. So we went over this in the earlier modules, but if there's some sort of jurisdiction issues, meaning let's say you get served, but you've never set foot in California. The person who filed in California moved there a month ago, decided to file there, and then you're served in, let's say, Nevada. You can do a motion to quash. So outside of jurisdictional issues, you're usually going to just file the response. But if there are some issues, meaning, hey, you've never set foot in California, the court has no reason to have you come to California to litigate this because you lived in Nevada your whole life. There are things that you can do to basically say, hey, California, you don't have jurisdiction over me, so I'm not even going to file a response. I'm going to file a motion to quash, or say this is improper for whatever reason. So challenge the jurisdiction, you can make what's called a special appearance and contest the jurisdiction by filing a motion to quash in whole or in part. So then this will essentially, if the court says, yes, you're right, hey, the person who files here in California has only lived here for a month, you and your children have lived in Nevada your entire lives, we're going to grant your motion to quash, then the petition basically is dismissed, and then you'll have to either file in Nevada or do whatever it is you need to do, or establish residency in California, and then you can try to, say, well, now California has the right to exercise jurisdiction. But if the motion to quash is granted, then the petition is basically dismissed, and then you have to either file in the correct jurisdiction or wait it out so that California does have jurisdiction. You can also do a change of venue or a motion to transfer. This comes up every once in a while. So again, venue and transfer, sometimes, somebody will live in one county and then come to Orange County or vice versa. And there are a list of factors that the court will consider to determine whether or not there is another county that may be more appropriate. It's usually depend on, where are the witnesses, where do the children reside, which will have the least economic detriment. So for example, if one person lives in a county where that's where most of the witnesses reside, the children reside, then they'll usually, grant the change of venue. But it really is fact specific, and you have to list the reasons as to why you're seeking change of venue or why you're trying to move it to another county. CRC, so that's California Rules of Court, makes provisions for filing a motion to strike certain items contained in the petition not specifically required in FL 100. And a similar motion can be made by petitioner regarding improper items contained in the response. So you can do all that, but again, these types of requests for change of venue or change of location or quash, they rarely come up. It will most likely come up if you are representing the respondent. So if somebody comes to your office and says, hey, I was served with this petition, but I don't live here. You see here it says Orange County, but we've lived in Riverside County our entire lives. So it's usually done by the respondent. There are times when the petitioner will file a change of venue, even though they initially sought the venue for whatever reason. I had one case like that. It was very confusing and confounding. And one of the arguments I made was, hey, they're the person that wanted this jurisdiction in the first place, and now they want to change it. So again, very, very fact specific. Filing and service requirement. Once the various papers have been prepared, they're filed with the appropriate office of the Superior Court and then served on responding party. So here in Orange County, if you are an attorney, you are mandated to use any one of the various e-service providers. I use Odyssey, and we have to e-file. I believe if you are pro per, you can still hand file or maybe even mail file or do counter filing. But as attorneys, and if you guys all end up working for a law firm, you guys are going to be required to use e-filing. Fee is, it's still $435. So that used to change like every 6 months, it seemed like, but it has been $435 for the longest time. So each person, so when you file the petition, you pay $435. Sometimes it's referred to as your first appearance fees. And then also the respondent will have to pay $435. Both people have to file that with certain exceptions. You can make a fee waiver request, meaning if your income meets the threshold level, then sometimes the court will waive that filing fee as well as other filing fees. Usually if they're retaining my office, it's going to be hard to show that they're going to qualify for a fee waiver because they obviously have the funds to retain an attorney. So I rarely, if ever, do fee waiver requests. I've done a couple just because friends have asked me, and then I will, basically prepare the forms for them. And because of their economic situation, they may qualify for the fee waiver, so I'll do that. But in most instances, if you all end up, being a paraprofessional or becoming an attorney, it's going to be hard to justify that a client qualifies for a fee waiver. I have had cases where clients may start in pro per and then they retain me because something may have gone terribly wrong or it just gets a lot more complicated. And then they borrow money from their parents or friends or whatever, and then there's a fee waiver in place, and that may still be valid. But for the most part, working for a family law attorney, this isn't a form that you're going to normally see. So there is an exception for the filing fee for a respondent. So if the parties agree to all terms, and let's say it's a relatively simple divorce and everyone comes to the table, everyone agrees, the attorney is essentially acting as a scrivener. They're literally just, preparing the document. There is a method where you can file as a default uncontested matter. So if you proceed as a default uncontested matter, then instead of having to file the filing fee, what happens is that the ultimate judgment or settlement agreement, that agreement has to be notarized by the respondent because the court wants to make sure that whoever is signing the settlement agreement is the person who proposes it to be. So if you file a default, but it's still uncontested, then you don't have to pay that $435, but you do have to get the settlement agreement notarized. So that's the only other exception I can think of where a respondent does not have to pay the $435, but the petitioner still will, again, outside of a fee waiver request. Let's see. This has to do with default or uncontested proceedings. That is true. You can, well, for my practice, again, ultimately they may end up with an uncontested or a default judgment after many, many tries, but a fair amount of these matters that my office handles, does go all the way to trial. I have found that more and more people are going to trial. It used to be that, a big percentage of my cases, we would ultimately settle, cooler heads would prevail. But I have found it's just more and more people are just litigating it. They, for whatever reason, they need to either have their day in court, they want to be heard by the judge, or they need to hear it from a judge. They will often say to me, I just need a judge to say that to me. So regardless if I, advise a client like, hey, listen, I think you have a good chance in this, or you're not going to win on this, or whatever the situation may be, it may just be that they need to hear it from a judge, or they want to be able to tell their story to the judge. So I have found more and more that a lot of my cases are going to trial, even as of 5 years ago. Maybe it was COVID related. And now that I'm thinking about it, I think it was because pre-COVID, most, like I said, 80% of my cases would settle, but I'm just finding more and more where everything is being litigated. I went over this. If they fail to respond, you can ask for the default ruling. That's the 174. No, that's something else. Bear with me. Let me find the request for default. So you can do the request for default if the 30 days has passed, and then you can proceed by default. Here in Orange County, depending on the issues, if it's a relatively simple divorce, not a lot of assets, you're asking for a fair division of whatever assets may exist, the courts may just process that through just your written documentation and what you submit to the court. But more often than not, if there are children or there are, significant assets, the court will request that you prove up your default, which requires a hearing. So it really is fact dependent. But even if you do a request to enter default, you may still end up having to go to court, meaning the client or the party, along with the attorney or by themselves, whatever the situation may be, to prove it up. Because the courts are going to want to hear some sort of testimony as to why you're making the request that you are. Is it fair? Again, especially if there's children involved or there are a lot of assets and a lot of debts. And I believe in San Diego, it's mandatory. I don't think you can get a default judgment just with papers. I think in San Diego, they require a hearing regardless of what the nature of the case is. So they're going a little bit more about request for entry of default. I think this is important. So once a request for default is properly completed and filed with the court clerk will enter the default, meaning, okay, you're defaulted. You don't get to do anything more in this case. You can't appear. You can't make arguments. You're basically done. You can't do anything unless you file that motion to set aside. Default establishes respondent cannot appear at the hearing, cannot file any papers, cannot make any objections. For all practical purposes, is invisible in the eyes of the court. Absolutely 100% true. At this time, the court can set the matter for hearing on the default prove up. Again, every court is different. At a typical prove up, petitioner appears in court, provide paperwork and testimony. Some larger counties, petitioner does not need to personally appear. So again, it's very fact specific. I have found here in Orange County, it just depends on the cases. But if you need to do a prove up, that's fine. You just tell the judge, this is what I want and this is why I want it. And the judge will ask you questions. If there's any sort of deficiencies, they'll, ask you to either clear up the paperwork or do something else. Sometimes the court will, if you send in what's called a default judgment packet and there's something that the court wants to know more about, if they're nice, they will put in the reject paper, this is what we want. If you do this, then we'll, grant it through the papers. So once that step is completed, several other papers must be completed and submitted to the court. Declaration for default. I have that form. Let me show you guys. So the declaration for default or uncontested dissolution or legal separation, this is going to be a form that's used in judgments or for default. So if you have a settlement agreement and everyone agrees to the terms, this form will be used. If you ask for prove up, this form will be used. Again, pretty self-explanatory. So as I said, you have the default with the agreement, you have uncontested. They ask you a couple of questions about the PDDs, as I was telling you about. The courts need to know that at least one of the parties, the petitioner, especially if this is being done through default, has filed their PDDs, which is the income and expense declaration and the declaration of disclosure form. I think I put that in. Hang on, let me open that up for you guys because that is actually an important form. So depending on how the matter proceeds, you don't necessarily file the income and expense declaration or the schedule of assets and debts. Definitely not the schedule of assets and debts, and sometimes not even the income and expense declaration. But you do need to prove to the court that you served it. So it's called declaration regarding service of the declaration of disclosure and income and expense declaration. Again, unless this form is prepared and filed with the court saying, yes, I have filed, either petitioner or respondent has filed a preliminary declaration, they're not going to allow you to get a judgment. So this form is very important. This form needs to be filled out and filed in any sort of legal separation or dissolution case. I've shown you guys that FL 150, again, very important form, lists their income and expenses. Pretty much this form is self-explanatory. There's one page that has all your income, which is page 2. Page 3 has all your expenses. And then page 4 relates to child support information. So again, this form is always used. I always use this form, and I use my paralegals to prepare this form and to go over the forms with the client. Again, more in my office as more of a cost saving measure so that the clients aren't paying me my hourly rate to go over this. They can have my paralegal do this because it's just a lot of basic information. Okay, so the judgment. Okay. So this is the judgment. It's 2 pages, and this is, you can write the dissolution, legal separation, or nullity. So status only. So in certain instances, I believe we discussed this in the prior module, but sometimes divorces take a long freaking time because there's either a lot of assets or there's child custody issues. You may be going through a 730 custody evaluation, or maybe there's forensic accounting involved. So you're like, geez, I cannot wait all this time for all these things to resolve. I need to get divorced because I know I'm in another relationship. I want to get married. So you can also do just a status only, meaning, hey, your status is bifurcated. You are no longer legally married. You're divorced. All other matters are still reserved by the court, but at least we're going to let you get divorced. Policy favors status only dissolutions, meaning outside of some reason why a status would be detrimental. There are definitely some instances where it is. For example, health insurance can sometimes be a big issue because once a person is divorced, they usually can't stay on, let's say, a group plan. But there are ways to compensate for that, meaning, let's say the person says, I don't care, I understand, my wife can no longer be on my health insurance, but I will pay for whatever it costs to have her get her own health insurance. So you can do a dissolution for status only. You can do dissolution reserving jurisdiction over termination of marital partnership, meaning you've done everything other than this jurisdiction of termination. Again, this is used when there are maybe health insurance issues or there's some other issues that can come about. I know with some of my military clients, if you sever the marriage and they don't get some sort of military benefits again. So there's a lot of different reasons why you may want to resolve all issues other than status. So it's a 2-page form. Again, pretty self-explanatory. Judgments will either be default or uncontested, meaning you guys have come to an agreement by declaration. Contested means you've gone to trial and you're going to write down the judicial officer who was all present, and then you'll, include whatever the judgment was of the court, or agreement in court. Sometimes on very happy days, you guys will go to court and the parties come to an agreement, and then you check off this box. But again, you have to use this form when you submit a judgment to the court. This is one of those mandatory forms. However, my judgments will have a 50 to 60 page settlement agreement or a stipulated judgment. So as you can see, for these, they want to know how each of these issues were adjudicated: child custody, support, spousal support. And you'll see for most of this, it will say as set forth in the attached settlement agreement, as set forth in the attached settlement agreement. So again, for most law firms, they'll have a settlement agreement or a stipulation for judgment. So you'll just check that off, and then you'll have the number of pages that are attached. But you do have to use this form. This will be on the front of the settlement agreement, the stipulated judgment, whatever agreement there is. Okay. And then notice of entry of judgment. Put that in. Let me open that for you guys. Okay. So this is another mandatory form. You'll fill this out with the, firm information and whatever court it's in, and you'll just mark off whatever dissolution or legal separation, whatever may be applicable. And then you provide this to the court. You fill in this part, even though it says clerk certificate of mailing. I know as form and practice, you still fill out this. The only thing you leave blank is what the clerk actually signs. You provide an original, 2 copies, 2 self-addressed stamped envelopes, one that will go to petitioner, one that will go to respondent and or his attorney or her attorney, and then they mail it back saying, hey, we've entered your judgment. So this shows that there's been an entry of judgment in your divorce action. So these are the forms that are used in default and uncontested hearings. Trying to think, I don't think there's any sort of other oh, there is a local form. Okay. Orange County has this great local form, which I love. So we have what's called an expedited processing attachment to dissolution. I love this form. If you use this form, and again, a lot of this will be duplicative or repetitive of what's in most attorneys' settlement agreement or stipulated judgment, but it kind of ensures, it's like a little checklist to ensure that you, if for whatever reason, statutory language is missing from your judgment, this little form essentially puts it right in there and it's attached to the judgment so that you don't get your judgments kicked back. So one of the most frustrating parts of practice is getting things kicked back from the court for whatever reason it's getting kicked back. I've been doing this for years and years and years and years, and literally if for whatever reason one thing isn't checked off or whatever, Riverside is notorious for being like too much of a stickler or just not even looking at the file to know that they can't reject it for the reasons that they're saying they're rejecting it for. But here in Orange County, we have this form. So if you fill this form out completely, number one, you make sure that even if you may be missing another form or your settlement agreement or stipulated judgment doesn't have the necessary language, this form will take care of it. Not only that, if you don't use this form, I would say the usual waiting time right now is about 3 months to get these things processed, the judgment process. But if you use this expedited form, it is much quicker. It's been a little slower than I used to, but literally about a year ago, if you submitted a judgment with this form, you would get it back within a week. I think it's more like a month now, but it's certainly still less than if you just do it with the regular processing and don't use this form.
Does LA
I
have
always use
an
this form.
expedited form?
Excuse me?
Does LA have an expedited form
I don't
also?
believe so, but I don't believe they do. But my experience with LA is that they are very quick in processing their judgments, and at least at some point, I don't know if they still have this now, but on their website, they used to have a page where it would show you the current date of when they're processing judgments. So for example, if I logged on right now, they would say, okay, we're now processing family law judgments that were submitted on November 1st. So they used to have a page like that. I don't know if they got rid of that or not, but my experience with LA is they process documents fairly quickly. And depending on your judge, I've had judges sign off on things like even within the same day. But I do not believe they have the equivalent of this expedited processing attachment.
Thank you.
Of course. Okay. Okay, so yeah, difference between default and uncontested. With the uncontested, both parties are signing off on the marital settlement agreement or the stipulated judgment. So for the uncontested, rather than by default, respondent will participate by virtue of filing the appearance stipulation and waivers. I believe I put that up, but let me just show you guys what that is. So this is another form that is generally used. And again, if for whatever reason you forget this form, on the expedited form, it kind of takes care of this. So appearance by respondent, you just write by filing this form, I make a general appearance. If you do this again, then you have to pay the $435 fee, the filing fee, the first appearance fee. If you just do the pure default with agreement, then you just have to get the stipulated judgment notarized. So if they want to, for whatever, pay the filing fee and not have to deal with a notary, maybe it's a bigger deal to, find a notary, get all that signed. You can file this form, check off 1A, check out any of these that are relevant, and then you sign off on it, and then you will file this along with the other documents. Most family law trials are conducted in much the same manner as other civil trials. I 100% disagree with this. I came from a civil background, and I can tell you I was really, I'm not trying to be hyperbolic. I was really shocked at how different family law and civil law, how their trials processes are handled. I think civil law is much more rule-based. They will look at civil procedure. They do things in a very systematic way. Because family law is a court of equity, I do not find that the trial and the way they proceed with trial is as orderly as a civil court. There are many times things will get bumped because DV always takes precedence. DV and contempt motions always take precedence. So you may be all ready to go to trial, but the judge may have, a DV case that's been pending. So they'll say, just come back. I never experienced that in civil, just because I don't think it's as impacted or busy. So while family law still follows civil procedure, or they're supposed to, I find that it's a little more lax insofar as introducing evidence and other things of that nature. And I think this is important for paraprofessionals and paralegals, or obviously if you guys end up going to law school, which again, I encourage you guys to do. But if you want to just stay at the paralegal level, you will be able to help your attorneys in ensuring that, the exhibit binders, the exhibits, will all be admissible. And I use my paralegal to go over all the evidence that I ultimately intend on introducing at trial, to see if there are any admissibility issues, or to make sure that they're properly organized. Again, every judge has his or her own proclivity. But family law is supposed to follow in a civil procedure, follow the discovery cutoffs. It's a little different because we have a lot of post-judgment issues, which reopens discovery. And then the other major difference is with civil, you can have jury trials. And I've heard that you can request a jury trial in family law. I have never conducted a family law jury trial, and I think there may be a disagreement about this, but I certainly have read case law that says that because family law is a court of equity, a jury is not, you can't demand a jury trial in family law, whereas you can in civil. And obviously, if you start doing civil and there's jury trials, that's a completely different can of worms. So I disagree with this in so much as family law is supposed to be like civil law, but in just practical practice, I don't think it's the same. I don't see it. Once a lengthy or complex case is within 60 to 90 days of the date of trial and has an estimated trial date in excess of 1 or 2 more days, the trial judge will generally call both counsel into chambers for a pretrial conference. I also do not find that to be true. I know some judges loathe chambers. You have to sign off. I think there must have been something, but because judges used to do a lot of chambers, but I do not see this a lot. There are certainly judges who do conduct chambers, which is nice. They'll kind of give you some of the way that they're thinking and kind of give you tentatives, and you kind of know which way the judge is going to go. And that's very helpful because then you can come back to the client and say, hey, this is what the judge is saying. I have found that most of the judges here in Orange County will discuss all these things that they're saying will be discussed in chambers actually in the open courtroom, so that there's a record of it, so that the parties can hear it. Because I know sometimes parties may feel like, well, are they having secret conversations? What's happening? I need to know what's going on with the case. So I think, at least with the family law judges, I have found that they try to do a lot of this stuff on the record, I think just to avoid any sort of feeling that the client is not hearing something, or that, who knows? I mean, nothing happens. Certainly not in my practice have I ever run into any sort of judge who is saying something inappropriate, or an opposing counsel that is saying something inappropriate in chambers or unethical or anything like that. So I have found that most of these discussions about trial will happen in the open courtroom. So again, I don't think the trials are as important for you guys unless you do become attorneys. I certainly, my paralegals do not come to trial with me. There are other firms who do have their paralegals there just to give them paperwork, and if it's a big case, to make sure that the proper exhibits are there and to make sure that the binders are there. But for most instances, these are, when you go to trial and do all these things, it's usually the attorneys that are involved. Let's see. Conciliation court. We don't have a conciliation court here in Orange. Let's see. So once petition has been filed, court sets a time and place for the hearings and will give notice of the hearings to all interested parties. So again, I don't know if they're talking about Orange County does have mandatory settlement conferences. They're mandated. Most judges will force you to undergo a mandatory settlement conference before they will set a trial date. I often also use private mediation, because my sense is if you pay for a mediator, and mediators are very, very expensive for the most part, but it's still cheaper than having to go through a full trial, where even though you think you're getting half the afternoon, the courts take breaks. And when it's all said and done, in all reality, you probably get 2 to 3 hours, of straight testimony, because there's a lot of breaks. There's a whole bunch of stuff that goes on. So, instead of spending that time with your attorney who has to bill you for travel time, sitting there, even if you're supposed to start at 1:30, if there's some sort of matter from the morning that bleeds over into the afternoon, the attorney's still sitting there, they still have to charge you. Whereas with the mediator, they give you 100% of your time, and you can try to mediate it and get it settled. Most judges, if you tell them, hey, we've been through private mediation and no dice, we still couldn't settle, they're not going to force you to go to the MSC, but certain judges still do. Yeah, so mediation. I love mediation. I think it's great. We have a lot of our retired family law judges who now work for, ADR, Adjudicate West, JAMS, Signature Resolutions, and then they offer their services as somebody who has sat on the family law bench. And they're very, very helpful, because obviously they know the law, and even though they're not sitting, in a courtroom, they can tell your, clients, hey, this is the way I see it. This is what's going to happen. So why waste all your time and money arguing about something that you're probably not going to win, or that you are probably going to win? So I think mediation is great. Sometimes, again, just depending on the parties, I certainly have clients who say, no, I just need to hear it from the judge, or I have to talk to the judge. I don't care if this person sat on the family law bench before. I want to talk to a judge. But I always encourage my clients to go to mediation to try to get things settled, because in the long run, it's a lot less stress. Usually it's a lot less money, and you have an opportunity to essentially come to an agreement. You may not be happy about it, but you never know what a judge is going to do. I think the most frustrating part of family law is, each judge is different. They come with their own background, they come with their own story, and you know, the same set of facts with one judge versus another could end up in a completely different result. And I know when I first started practicing family law, that was a really big source of frustration for me, because unlike civil, where it's usually, you know, the civil procedures there, you kind of know what you're dealing with. In family law, it is so emotional. You know, there are a lot of things that are very fact specific. And again, a judge with a certain background may not think something that's important to you or your client is important, or something that you didn't even think of as an important thing, or you just kind of thought of it as some sort of, you know, a little issue. They may glom on to that. And it's very hard to know what a judge, not interest, that's not the right word, but what a judge focuses on. And part of the issue with that is, as I said, you know, when the judges are constantly rotating and you may have 3, 4, 5 different judges, even within one proceeding, that makes it really, really difficult and really hard to navigate and really hard to advise your client as to what to expect. Because obviously most clients are hiring attorneys to tell them, hey, this is what you can expect. And, you know, I feel like I'm copping out when I say I don't know, because sometimes I don't know, especially if it's a new judge or it's a specific or, you know, unique fact pattern, because ultimately I'm not the judge, and the law, especially in family law, doesn't necessarily have a lot of bright line rules that say, okay, if this, then that, because a lot of it is just based on equity and whatever the judge decides to do. So, okay, I'm going to stop here. Once again, I feel so blessed and happy that you guys were my first students. I truly hope you enjoyed the class. I welcome any and all feedback. You guys were an absolute pleasure. So patient with me. Thank you so much for being patient and allowing me to share my experiences in family law. I hope you guys reach out to me. I would love to hear from every one of you at some point in the future. I will have all grades. I think I got an email from somebody saying everything will be done before the 12th, but I will be doing everything before then. But from now until the 12th or even thereafter, please stay in touch. I absolutely loved teaching this class. I enjoyed meeting you guys. Thank you for letting me blather on for 2 hours. And again, if you guys have any questions, even outside of this, just some practical advice, or you have questions that I didn't go over in class and you just have a personal interest, I put my cell phone on the chat again. Feel free to reach out to me. And I hope to see you guys in person someday. I'd love to see all of you guys in person. So you guys have a wonderful rest of the semester.
I'm sorry, can I interrupt before
Yes.
anybody goes? I really enjoyed this class. I've had some, you know, deaths in the family recently, so I've been kind of a little out and I missed last week's. But I am very willing to host a get together during this holiday if you guys have any interest, but I am in the Pasadena area. So
Oh, you're so
think about
sweet.
it if you guys are interested.
Thank you. Thanks, Helena. Oh, such a pleasure having you. Thank you guys so much. You guys were so awesome. I can't thank you enough. Again, please feel free to reach out to me for anything. I thoroughly enjoyed this. I couldn't have asked for a better group of students. You guys were awesome. I'm going to log off before I start crying. So thank you guys so
Thank you,
so
Professor.
much.
Thank you for
I
everything,
will-
Professor.
Oh, absolutely. And you know what?
You're very
I
class.
know last week's class, I have not been able to upload, but I will upload last week's and this week's. I was having my assistant do it, and she's out until tomorrow. So I will make sure that that is done. And I sincerely hope that I get to see all of you guys in person. sometime soon.
Thank you. You've been
Thank you,
wonderful.
everybody. Okay,
Thank
you have
you,
a wonderful
everyone.
holiday and good luck on the rest of your classes.
Thank you.
Professor, I
Thank
have
you.
a question.
Yes.
I was wondering, I was out last week because of Thanksgiving